3. Why not just do a conversion course? Dear Alex, thanks for your email. So, if I've got it right, you've been encouraged by my last letter to think you might want to become a lawyer. But now your history teacher is telling you that the astonishing hypothesis is astonishingly true, that doing a law degree is not necessarily the best preparation for becoming a practicing lawyer. And he's been telling you that Lord Sumption, one of the latest recruits to the Supreme Court of the United Kingdom, agrees with him. Well, remember that even if the astonishing hypothesis is correct, there are still plenty of other reasons, which I identified in my last letter, for studying law at university. However, I'll use this letter to address the astonishing hypothesis and explain why I think it's wrong. But first I have to clarify something. The astonishing hypothesis comes in two forms: a strong form and a weak form. The strong form of the astonishing hypothesis says that if you want to be a practicing lawyer, it would be positively better to do some degree other than law at university, and then do a 1-year conversion course, otherwise known as a GDL, for Graduate Diploma in Law, that will ground you in the basics of law and allow you to go on to the professional training 1-year courses run by a bar school if you want to be a barrister, or a law school if you want to be a solicitor. The weak form of the astonishing hypothesis says that if you want to be a practicing lawyer, you have no reason to want to do law as opposed to any other degree at university. In other words, doing a law degree provides no better preparation for becoming a lawyer than doing any other degree does. So in this letter, I'll be explaining why I think both the strong and weak forms of the astonishing hypothesis are incorrect. Let's start with the strong form. The strong form of the astonishing hypothesis. Lord Sumption seems to be a supporter of the strong form of the astonishing hypothesis. If you want to practice law, it would be positively better if you did some degree other than law at university. Your history teacher probably came across a report of Lord Sumption's views that was carried in the Daily Telegraph on July 8, 2012, and which you can easily look up online. But the Telegraph was reporting on an interview which Lord Sumption gave to the Barristers Magazine Council, and which was published in July 2012. That interview is not available online, but Council Magazine have kindly agreed to allow me to reproduce the relevant portion of the interview here. Would you recommend people coming to the bar to do a law degree? Or would you say there is as much value in doing an arts subject as an undergraduate? I've made a lot of enemies, though I have to say very kindly enemies, by saying publicly on a number of occasions that I think it is best not to read law as an undergraduate. I've sometimes been misinterpreted when I say this as suggesting that law is not well taught to undergraduates in British universities. That is not my view. I think it's superbly well taught to undergraduates in British universities. The problem is that we have a generation of lawyers, and this applies to solicitors as well as barristers, who are coming into the profession with much less in the way of general culture than their predecessors. It is very unfortunate, for example, that many of them cannot speak or read a single language other than their own. I think the difficult thing about practicing law is not the law but the facts. Most arguments which pretend to be about the law are actually arguments about the correct analysis and categorization of the facts. Once you've understood them, it's pretty obvious what the answer is. The difficulty then becomes to reason your way in a respectable way towards it. Of course, sometimes you just can't, in which case you change your mind. This is why the study of something involving the analysis of evidence, like history or classics, or the study of a subject which comes close to pure logic like mathematics, is at least as valuable a preparation for legal practice as the study of law. Appreciating how to fit legal principles to particular facts is a real skill. Understanding the social or business background to legal problems is essential. I'm not sure that current law degree courses train you for that, nor really are they designed to. That is not a criticism of the course. It's simply a recognition of the fact that a command of reasoning skills, an ability to understand and use evidence, and a broad literary culture are all tremendously valuable to any advocate. If you don't have them, you are going to find it more difficult to practice. If you don't know any law, that is not a problem. You can find it out. Notice how the interviewer is simply asking about the weak version of the Astonishing hypothesis. Is it true that there is just as much value in doing a degree such as history if you want to become a barrister? But Lord Sumption goes much further and says that if you want to be a barrister, it is best not to read law as an undergraduate, emphasis added. There he is endorsing the strong version of the astonishing hypothesis that if you want to become a practicing lawyer, you should positively not study law at university, but should do something else. In order to explain why I reject the strong version of the astonishing hypothesis, I want to pick up on two things Lord Sumption says in the passage above. 1. A generation of lawyers, with much less in the way of general culture than their predecessors. At the moment, law firms and sets of chambers tend to recruit from students who have done a law degree and students who have done a degree other than law on a 50-50 basis. That is, about half of the people to whom they offer a training contract, if they are a law firm or a pupillage. If they are a set of barristers' chambers, will have done a law degree, and the other half will have done some law degree other than law. So if Lord Sumption is right, and I'm in no position to say that he is wrong, that there is a whole generation of lawyers coming into the profession with much less in the way of general culture than their predecessors, that would seem to suggest doing a degree other than law is not the solution to this problem. Those who are coming into the law profession with non-law degrees suffer from the same lack of general culture as those who have done law degrees. If this is right, then it seems that the source of the problem that Lord Sumption is worried about has nothing much to do with what degree the new generation of lawyers did at university, and is more rooted in our culture, which tends not to encourage people to use their spare time to read Tolstoy, or learn a foreign language, or attend a set of evening lectures on astrophysics. If Lord Sumption wants to do something about this problem, then he would do better to address this general feature of our culture, rather than offer the completely inadequate solution of urging would lawyers to do a degree other than law at university. So Lord Sumption's only argument in favor of doing a degree other than law at university doesn't get off the ground. And in fact, it could be argued that one part of the solution to the problem Lord Sumption identifies is to encourage prospective lawyers to study law at university. Law is so multifaceted involved as it is with every different aspect of our society that studying law at university requires you to make much more of an effort to acquire more in the way of general culture than you would have to if you were studying, say, mathematics or classics. Studying criminal law or criminology requires you to know something about economics, philosophy, psychology, and sociology. You can't study contract law or tort law without knowing something about economics and philosophy. Studying constitutional law or jurisprudence requires you to know something about political theory. The same is true of international law. And students of international law would also be well advised to take an interest in game theory. Game theory is also relevant to family law, particularly in the way family law handles breakdowns of relationships, as are sociology and psychology. Intellectual property law can only be done well by students with a combined interest in science, economics, art, and literature. Comparative law encourages you to take an interest in the legal systems of countries on the continent. Many universities offer their law students the option of spending a year in a foreign country studying law, which helps to expand their horizons and develop their foreign language skills. And history is relevant to all of these subjects because when we study law, we are looking at how past decisions and the influences that were brought to bear on those decisions have influenced where we are now as a society. So if a would lawyer wants to enter the legal profession with much more in the way of general culture than his or her contemporaries, then studying law at university would be an ideal way of doing that. 2. If you don't know any law, that is not a problem. You can find it out. I want to make 2 points about this statement. First, Lord Sumption has just been promoted to the UK Supreme Court. I wonder, when he and his colleagues are faced with a difficult legal question, which is the only sort of question that gets to the UK Supreme Court, whether he tells them, "I don't know what the problem is. We can just find out what the law says on this issue." Of course he doesn't. That's because there is nothing to find out. When faced with a difficult legal question, The UK Supreme Court has to decide what the law says on that question. But they aren't free to adopt any method they like of deciding this question. They can't, for example, toss a coin to decide what the law says. They have to decide the case in a way that best guarantees that they will make a reasonable decision. That requires them to show some humility and take account of any views that have been expressed by other lawmakers in the past that might be relevant to the decision that they have to make. It also requires them to think hard about what implications their decision might have. Will it have undesirable effects on people's civil liberties or be harmful to the public interest in some other way? Will it make it harder for people to understand what the law says? Will it encourage future judges to develop the law in undesirable directions? Will it undermine Parliament's intentions as to what the law should say in this area? Learning to reason in this way takes time and discipline. Doing a law degree helps you to do this, and doing some other degree does not come even close to helping you to apply your mind to legal questions in this kind of way. Of course, you could argue, but only judges need to learn how to reason in this way. But barristers who want to get a judge to decide a difficult legal question in favor of their client also need to know how the judge is likely to approach that decision. And solicitors who need to advise their clients on difficult legal questions need exactly the same skill. And that skill of knowing how to think like a lawyer is best acquired by doing a law degree. Second, consider the following situation. An explosion occurs at a huge petrol refinery. The explosion damages the fabric of a number of houses nearby. The owners of the houses want compensation for the damage done to their houses. Someone who was renting a room in one of the houses has had to move out and is finding it difficult to find equivalent accommodation at the same rent elsewhere. She also wants to sue for compensation. You don't know anything about what the law says in this area, but Lord Sumption says that isn't a problem, you can just find it out. So go on. Find it out. How would you go about finding out whether or not the people involved in this situation are entitled to compensation? You would obviously need access to a law library, so let's assume you've got that. But where do you go then? There is no book on explosions at petrol refineries, and there is no book on the law of compensation. You might, in wandering through the library, find some books on land law which tell you about the rights of owners of houses and tenants who lease property, but they don't deal with this situation. At this stage, you might get a bit desperate and ask someone who actually knows something about the law where on earth you should be looking, and he or she might point you in the direction of the books on tort law. But when you get to those, you will be dismayed to find that they are all over 1,000 pages long. So short of reading all 1,000 plus pages of the book, how do you find out which part of the book you should be looking at? In fact, you should be looking first of all at the section of the book on the rule in Rylands v. Fletcher. But if you haven't done a law degree, but done some other degree instead, and then a conversion course, you probably won't know about the rule in Rylands v. Fletcher, because it is very likely that your conversion course provider decided in an attempt to teach its students 7 legal subjects in just 1 year that the rule in Rylands v. Fletcher could be dropped from the syllabus. So how would you know to find out what the law says on the rule in Rylands v. Fletcher when you don't even know that the rule exists? The truth is that the best way of putting yourself in a position to find out what the law says on any given legal issue is to do a law degree. Anyone who doesn't do a law degree and wants to find out what the law says on a particular question will almost inevitably find themselves depending at some point on other people who have done law degrees to give them a helping hand. I think if I wanted to be a practicing lawyer, I would rather be the kind of lawyer who has, through doing a law degree, acquired a good overview of the different areas of law and knows how legal knowledge is arranged in a law library, so that I can work on my own to research a legal issue and reach a reliable conclusion on that issue. And I wouldn't want to be the kind of lawyer whose state of knowledge depends on the vagaries of what I was taught on my conversion course and any tidbits of knowledge that I had been able to pick up from other people after entering the profession. The weak form of the astonishing hypothesis. I think I've said enough by now to show that Lord Sumption's arguments in favor of the strong form of the astonishing hypothesis simply don't stand up. 1. Doing a law degree is at least as good as any other degree in helping a would-be lawyer acquire the sort of general culture that Lord Sumption thinks it is so important that a practicing lawyer have. And there is good reason to think that, in these benighted times, doing a law degree does a much better job than most other degrees of encouraging a would-be lawyer to develop the kind of hinterland that Lord Sumption would like to see practicing lawyers have. 2. Doing a law degree is a far better way of helping a practicing lawyer acquire the knowledge and skills that he or she will need to find out what the law says on any given issue, or in cases where the law is uncertain, to make an educated guess as to what the courts are likely to decide the law says. If points 1 and 2 are correct, then we should also reject the weak form of the astonishing hypothesis. It is not the case that a would-be lawyer has no reason to prefer studying law at university, as opposed to doing some other kind of degree. There are a number of reasons why someone who has made up their mind that they want to be a practicing lawyer should positively want to do a law degree at university. Not just the reasons I've already mentioned, but also 3. Law students at university get lots of opportunities, through things like law societies and law events, to make valuable connections with law firms and sets of chambers that can help them pursue a legal career later on. They are also given far more opportunities than non-law students to develop the sort of skills that will make them attractive to law firms and sets of chambers. So, for example, a decent university law society will regularly organize moots, that is, opportunities to argue a legal point in front of a judge, which provide good preparation for life as a barrister. Whenever a law firm contacts me to ask if it can put on an event for my law students, I always ask them to do some sessions on commercial awareness and negotiating skills, as those abilities are particularly prized by law firms. But it's my law students who profit from those sessions, not students who have opted to do some other degree. 4. It is increasingly the case that students are expected to have done a postgraduate degree in law if they want to pursue a career as a barrister. It is obviously much easier for a student to do such a degree if they have already studied law as an undergraduate. I am not saying that it is impossible for a student who has done something other than law and has then done a conversion course to do a postgraduate degree in law, but it is obviously much tougher. 5. The conversion course is also tough. Someone who does the conversion course has to master 7 different subjects in 1 year that students who have done a normal law degree get to spread out over 3 years. This doesn't stop people doing the conversion course and doing it well, but it is not a pleasant experience and one that could have been avoided by simply doing a law degree. 6. And someone who does a conversion course only gets to study 7 legal subjects. In contrast, a student doing a 3-year law degree could expect to study at least 12 different areas of law during the course of his or her degree. This gives a law student a much broader understanding of the law and a much greater opportunity to discover what sort of areas of law really excite him or her, and that he or she would like to specialize in after leaving university. 7. Law students get a 1-year head start over their non-law contemporaries in pursuing a legal career. They are exempt from having to do the first year of law school or bar school, which is the conversion course, and can go straight on to the second year, which is concerned with professional training. At a time when education is becoming increasingly expensive, it is not clear why someone who knew that they wanted to be a practicing lawyer would incur a whole extra year's worth of fees and expenses doing a conversion course, and put off by a year the date when they can actually start earning some money, so that they could study some other subject at university. 8. As I said above, law firms and sets of chambers tend to recruit law and non-law graduates on a 50-50 basis. That might indicate that they endorse the weak form of the astonishing hypothesis. They don't care what degree you have done at university, so why should you? But if that 50-50 ratio is maintained in future, then that has an important implication for people's abilities to get jobs in the legal profession while the current economic crisis continues. Ever since the crisis began, jobs in the public sector and the financial sector have dried up. This has resulted in a big increase in non-law graduates applying for law jobs. So in the current crisis, the amount of competition for a law job that you might face as a non-law graduate will be far higher than you would face as a law graduate. One way of appreciating this point is to imagine that all jobs with law firms are stored in a building with two equally sized doors, one marked law graduates and one marked non-law graduates. The more people who are attempting at any one time to get through the door marked non-law graduates, the harder it will be for everyone entering through that door to get into the building. But two things make it even harder for non-law graduates to get law jobs. First, in an effort to cut their costs, the big city law firms are reducing the total number of training contracts, initial offers of employment, that they are willing to award graduates coming out of university. So the doors into the building of law firm jobs are shrinking at a time when ever more non-law graduates are trying to get into the building through the non-law graduate door. Secondly, every big city law firm I have talked to is tilting towards recruiting more law graduates than they do non-law graduates on the basis that law graduates are less of a risk. So in future, the non-law graduate door into the building of jobs with law firms may get much smaller, and the law graduate door proportionally bigger. If this happens, the odds of getting a decent job with a city law firm will be far better if you have done a law degree than if you have done a non-law degree. Summary. I'm afraid to say that your history teacher is wrong. The astonishing hypothesis that there is no particular reason why someone who wants to be a practicing lawyer should study law at university turns out, not so astonishingly, to be incorrect. That is why there is no other country in the world that allows someone to practice law without having done a law degree first, just as we here in the UK would never dream of allowing someone to practice medicine without having first done a degree in medicine. The continuing cachet that the astonishing hypothesis enjoys among some people in the UK has a lot to do, I think, with the very English cult of the amateur, the belief that it is possible to achieve great things without really trying, and without engaging in any specialized preparation or training. Wherever it rears its head, this cult of the amateur always has baleful effects. It explains why English football was for so long, and in some ways continues to be, a backwater in terms of skills and concrete achievement. It accounts for the UK's long industrial decline compared with other countries that take more seriously the need to ensure that a proportion of their population develops technical skills in engineering and the sciences. The UK needs to be immunized against this cult. Rejecting the astonishing hypothesis would be a very good start. All best wishes, Nick.